This is Mike Franklin, a property tax guy, and today we're going to review a couple pending cases I have down in Vestal, New York, which is in Broome County in the 6th Judicial District. This is Supreme Court Justice Eugene Faughnan. He's the administrative judge for the 6th Judicial District. I will show you the 6th Judicial District is the southern tier of New York, Delaware County, Otsego, Chenango, Madison, Cortland, Broome, Tioga, Tompkins, Schuyler, Chemung. Okay, so it's the main office is in Binghamton, and Vestal is just east of Binghamton. But it includes such areas as Cooperstown is in Otsego County, Oneonta, Delaware County. It's Binghamton. Let me see. You got Elmira, Watkins Glen, and Ithaca. So that's the 6th Judicial District, and Eugene Faughnan is the administrative judge for this district of the Unified Court System, 6th Judicial District of New York. So what we're talking about here today is I had two pending cases, small claims assessment review cases, and I requested I be allowed to record those hearings. And I got first I got an email back from them saying it was denied, and it didn't even say who it was from. So I wrote a letter. It's like, if you're going to deny me, my First Amendment rights, I need to know who's doing it. So they sent me this letter, and it was written by Porter Kirkwood, District Executive, which is basically the right-hand guy to the administrative judge Eugene Faughnan. And so in this letter, he writes that the above-described petitions were filed with Broome County. Stephen Furry and Esquire and Jamie Smith Esquire, respectively, were appointed as hearing officers. We have received your emails indicating your desire to record these virtual hearings and your concerns regarding having a proper and fair and transparent hearing, which they put in quotes. As a result of these hearings will now be held in person in the Broome County Courthouse and will be open to the public. And then they're going to have to reschedule it. As to your request that you be allowed to record these hearings, this request is denied. Please review Real Property Tax Law 735 and Part 131 of the Rules of the Administrator of the Courts, which governs audio-video coverage of the judicial proceedings, the Civil Rights Law 52. Representatives of the news media may record proceedings upon proper application as more clearly set forth in Section 131.13. I'm attaching 131.1 and 131.3 for your reference. So he's citing Section 735 of the New York State Real Property Law, and I'll show you that in a minute. And then he's citing, so that's actual New York State law, Real Property Tax Law. And then he's citing Parts 131 of the Rules of the Administrative Judge. That is not law; that is policy of the Unified Court System. And so we're going to review those. And so let's start off with 735. Here it is. Section 735, determination, not precedent. No transcript of testimony shall be made of a small claims assessment review hearing. Okay, determination, not precedent. No transcript of testimony shall be made of a small claims assessment review hearing. The hearing officer's decision of a petition for small claims assessment review shall not constitute precedent for any purpose or proceeding involving the parties or any other person or persons except as provided in Section 739 of this title. So what does Section 735 say? Well, what does it mean? It means what it says. Determination, not precedent. In other words, on each case is determined based on its own merits and the testimony that's provided, not precedent. So there's no case law. You can't cite Plessy versus Ferguson, as an example. The hearing officer just hears the evidence and makes a decision. They don't use case law for what went on in previous SCAR hearings. It's probably because the hearing officers for small claims assessment review cases aren't necessarily attorneys and they're not judges. They can be real estate brokers. They can be a real estate appraiser. They can be a former assessor. and or they could be an attorney. So they're just making determinations. And my interpretation of 735 is that that's what it is. And they're saying no transcripts are to be made because none are necessary because there is no precedent. And but the administrative judge is saying that says you can't video record SCAR hearings, and that's not what this says at all. It just says determination, not precedent. That's what this section is about. The real property tax law doesn't deal in First Amendment issues, and that's what the administrative judge is saying here. So yeah, there's no transcript. We're not video recording this hearing for the purpose of a transcript. We're video recording the hearing to disseminate to the public so they can see what goes on in these hearings, so they can see how the assessor conducts his business, so that they can see how the hearing officer and the court conducts their business. It's about transparency and accountability. Section 735 simply is not relevant, but the judge says it is because he said so. If that were true, he wouldn't just cite 735. He would explain how 735 is relevant, and he hasn't bothered to do that because it isn't relevant. He's just trying to impose, the power of his position to say it's so because he said so. And what would be his reason for doing that? Well, he probably doesn't want to have these things, in other words, he's getting paid a salary to do a job, and he'd probably like to keep it as simple as possible. He doesn't, want to have all kinds of publicity as a result of these cases. He'd like to keep it nice and quiet and just kind of process it through. But I suggest that that's inappropriate. I think the public has a right to know what goes on in these hearings, and they have a right to know how the court operates. They have a right to know how the assessor operates, and actually the town board and the town supervisor and the town attorney, they should be allowed to watch these things so they can see how their assessor behaves because they probably do not know. And so this judge is trying to quash the transparency and accountability of this situation. So that's Section 735. I think any reasonable person would conclude, other than the judge, that 735 simply is not relevant. So then he cites Section 131.1. In particular, he's citing Section 131.1c. Audio-visual coverage of party or witness testimony in any court proceeding other than a plea and an arraignment is prohibited. Let me read it again. Audio-visual coverage of party or witness testimony in any court proceeding is prohibited. Well, we all know that that's not true. For example, Judge Judy, they recorded all of those hearings that she had. It was small claims, just like assessments. It's small claims, and they recorded them and disseminated them on the television. Why would Judge Judy be allowed to do that? And I cannot record it. They're supposed to be equal under the law. Well, I guess some people are more equal than others. So let's take a look at Section 131.1a. In order to maintain the broadest scope of public access to the courts, to preserve public confidence, which is a concern I have right now, in the judiciary, and to foster public understanding of the role of the judicial branch, that's what I'm trying to do, is show people how the court works, how these assessment hearings work in civil society. It is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings to the fullest extent permitted by the New York State Civil Rights Law and other statutes. We'll review Section 52 later. As interpreted by New York courts. So that keeps it rather open-ended, doesn't it? Pursuant to the rules set forth below. Okay, so we already read Section C, so that's A. Let me repeat it. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings. Now, that's quite contradictory to C, where it says it is prohibited. They're very contradictory. So they like to keep these policies rather vague so they can, do it one way or the other. Let's read Section D. Nothing in these rules is intended to restrict any pre-existing right, such as the First Amendment, of the news media to appear at and to report on judicial proceedings in accordance with law. So, 131D. 131.1D. Nothing in these rules is intended to restrict any pre-existing right of the news media to appear at and to report on judicial proceedings in accordance with law. Okay, so that's 131 that he's referring to. So again, it's not law. It's the rules of the court. It's their policies. It's not law. Constitution, state law, policy. So much for that. Let me show you a couple other examples of that it is not, in fact, denied. This is the DUI guy. He is an attorney in Kentucky, and he records his DWI hearings, where he cross-examines police officers, such as this fellow, and this fellow, and he does this all the time. He literally has hundreds of videos of his recordings of DWI cases. So if he can record them, why can't I? It's literally hundreds. I think that there's at least 400. Here's another guy. He's cross-examining this cop. Because it's important to make certain that the police treat the public properly. Everybody needs to be accountable, and in these hearings, I want to be accountable. I want the public to see that I'm not trying to get people more than they deserve. So again, here's Justice Eugene Faughnan, the Chief Administrative Judge. Okay, here's Berwyn, Illinois. This is the Long Island auditor. He goes and audio tapes public offices, post offices, police departments. And what we have here is a judge. And this is a recording of a hearing. So he had been arrested for disorderly conduct because he was recording in a city hall, which he in public areas, which he has an absolute right to do. First Amendment, same kind of issue that the judge has. And but here's a judge. She basically didn't. She said it was a fact-based case and it could not be dismissed. So it moved on to another judge to hear the case. And so then the Long Island audit asked that judge if he could record the hearing and live stream it on YouTube. And the judge says, "Why not? I'm all in favor of transparency." And when that happened, the prosecutor asked the case be dismissed because the prosecutor didn't want to be embarrassed because they had a ridiculous case. But the judge was going to allow it, and he has this guy. The Long Island audit has let me see if we got. He has 351,000 subscribers, and he's had approximately 7.6 million views. And I think that that's a larger audience than Syracuse.com, for example. But I would say it's certainly larger than any newspaper in Binghamton or any TV audience in the Binghamton area. Is he going to say that the Long Island audit is not a legitimate member of the press? Now, what I do, this is a nationwide thing, First Amendment issue, so he has a large audience. Mine is very specific to upstate New York, in specific areas in New York, and it's a very niche market thing with assessments that people don't pay attention to except when they get their tax bills. So I'm not going to have millions of views for such a niche market thing, but doesn't mean that I'm not a legitimate member of the press. Let's see if we have any other examples. Let's see. Oh, I don't have Judge Judy, but y'all remember Judge Judy, and then there's Judge Wapner, and all these judges are recording and disseminating these cases to the public. I guess when the judges can make money doing it, it's okay. But if anybody else wants to do it, then it's not okay. What else do we have here? So, all I can conclude when a judge provides sections but does not explain how they apply to the circumstance, it's a transparency and accountability issue. So it creates an appearance of impropriety, and it makes one wonder. Oh, by the way, here's one more situation. This is a fellow who's had issues with his assessor and with the small claims assessment review process, which is also in the 6th Judicial District, and he wrote an entire web page about his experiences, with the assessor, the Board of Assessment Review, and the Small Claims Assessment Review. It's Upstate New York propertytaxes.blogspot.com, and I tell you, what he has written here is a microcosm as to what my experience has been, and I've participated in cases. I was at 18, but I think I'm actually over 20 counties that I've participated in cases in so far. And this guy wrote a microcosm of all the experiences that I've had. It's just unbelievable. He describes the behavior of the hearing officer. He describes the behavior of various assessors, and it's really, really interesting. And I suppose the judge is going to say that he's not a member of the media either, I suppose. So when a judge behaves in that fashion, he makes a ruling that actually he's not supposed to be making. His hearing officers are supposed to make that determination. And by the way, there's when they do, you have to apply to record, and you have to fill out a form, and they ask you what's the name of your organization and your phone number, and some pretty basic questions. But they have to abide by here's these rules that pertain to application for audio and visual recording. So 131.3a, coverage of judicial proceedings shall be permitted only upon order of the presiding trial judge approving an oral or written application made by a representative of the news media for permission to conduct such coverage. Upon the receipt of an application, the presiding judge shall conduct a review as may be appropriate, including, number 1, consultation with the news media applicant. That was never done. And plus, one of the reasons it isn't done is because this isn't the job of the administrative judge. This is the job of the hearing officer, and that's why it hasn't been done. 2, consultation with counsel to all parties to the proceeding of which counsel is sought, who shall be responsible for identifying any concerns or objections of the parties, prospective witnesses, and victims, if any, with respect to the proposed coverage and advising the court thereof. So in other words, they should also ask the assessor what he thinks about the thing being recorded. Of course, the assessor won't want to record it, because he doesn't want to be transparent and accountable for what it is that he does. But the thing is, he is a public official, and he has no expectation of privacy. There is nobody else to ask. I and my client are willing to have it recorded, and the hearing officer has no expectation of privacy. So there's no one to object to this particular thing being recorded. They have to come up with a reasonable, articulable explanation as to why it would be inappropriate to record these hearings. And a reason that would be justifying not recording it or limiting the recording of it is if it would violate someone else's rights, such as a rape victim or a child, those things. But there are no victims in this case, so they have no justification to deny this. But anyway, 131.3 reviews all this stuff, and there's nothing in here that would give them justification to deny my First Amendment rights in this case. But anyway. Back to Judge Faughnan. So why would he deny this? I can only speculate as to why he would deny it, why he would not want to be accountable, why he would not want to be transparent, why he wouldn't want the assessor to be accountable and transparent. So I have to speculate as to why that would be. My guess is the main issue is that he's trying to minimize the amount of work that he has to do, that he and his people have to do. But this isn't about making their job easy. It's about administering justice. So he's getting paid. I didn't look up his salary, but probably $220,000. Pension and benefits, might be more. And so it's kind of a fixed thing. So he's not motivated to go above and beyond. He's just motivated to get through his day. So my guess is the main reason for him to deny this is to minimize the amount of work for he and his people. And maybe he legitimately thinks that I am not a legitimate member of the press, but he hasn't talked to me, he hasn't interviewed me, he knows nothing about me, so I don't know how he can make that determination. So why else would he not want this thing recorded? Well, again, I have to speculate. So let's speculate. Let's take a look at. This is his house. Okay, it's in the city of Binghamton, and I'm going to look at the property tax records on it. Full market value assessment for 2022 is $291,407,000. Let's take a look at the owner's sales. Single family residence. He bought the property in 2006 for $324,000. So let's take a look at Zillow. Let's see. Here we go. And so this confirms sold for $324,000 in 2006. Here's his assessment history. 196. That's the assessment. So the fair market value was 291. But he bought the property in 2006. But look at this assessment, 196,700. It has been the same since the year 2000. The market goes up, the market goes down, the market goes up, and yet these assessments remain the same. What does this tell me about the assessments in the city of Binghamton? It means, it looks to me like there hasn't been any assessments in the city of Binghamton in the past 22 years, at least, because that's as far back as this goes. Who knows how much farther it goes? 22 years, the assessment has not changed. What is going on in the city of Binghamton? But in any case, but his assessment back in all these years back, it's all been the same. And Zillow gives his estimate of $368,000. He paid $324,000 for 2006, and yet his assessment has remained the same. So when a judge is not accountable and transparent, it makes you have to speculate. And I don't know what else to think. But what I can tell you is I have a First Amendment right to the press, and I intend to record public officials in the course of their duties in a public space. They have no justification to deny me. There are no victims to protect. The assessor nor the hearing officer have any expectation of privacy. Let's see if there's anything more to say about this. I think that we've covered it all. 735, determination not precedent. It's got nothing to do with recording hearings. Section 131. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings. And yet he's denying me, saying I am not a legitimate member of the press. I have, as I mentioned, participated in these cases in at least 20 cases in 20 counties of New York so far. I've dealt with dozens of assessors. I was a hearing officer myself for 4 years in 6 counties. I'm a licensed New York State real estate broker, 20 years experience as to what properties list for, sell for, assess for, and appraise for. I don't know who has more experience in these matters in upstate New York than I do. Are you suggesting that CNN or Fox News, would be more appropriate? Would have somebody that'd be more qualified to disseminate all this to the press, than I am? It's concerning when a judge can decide who is legitimate media and who is not. Let's just say you had a Democrat judge who says that Fox is not legitimate, or a Republican judge who says CNN is not legitimate. It simply is not the judiciary's position to be making determinations as to what media is legitimate and what is not. The government cannot regulate the media. Judge Faughnan has no business denying me my right to record these hearings. It's an absolute outrage, and it's damaging to the public. These hearings are important. It's not important to the judge, apparently, because the SCAR program is nothing but a nuisance to these judges. You know, they could care less, but they don't understand that that property owners, you know, if they don't pay their taxes, their property will be auctioned, and even if they have equity in it in New York State, they wouldn't get it. That's not ownership. That's renting. And so what we're trying to do is uphold the illusion of home ownership, because home ownership is important because it creates a stable environment for people to raise children to become productive citizens. They are the foundation. It is the foundation of the country. You don't find homeowners burning police precincts, police cars, and car dealerships. It's important. It's important that there be justice in home ownership in the assessment process, that the assessment process be equitable. And this judge and this assessor are trying to hide that for whatever reason. It is not proper. It is outrageous that a state judge would interfere with the First Amendment right of a constitutional right of a member of the public. It's just outrageous. This is Mike Franklin, the property tax guy.